Most special needs plans in North Carolina are built wrong. Not because the lawyer who drafted them was lazy, because they were built before anybody even knew whether the child or the beneficiary was even going to qualify for disability benefits. I'll walk you through how to plan for an adult child with a disability when we're not really sure yet whether that child will actually qualify for disability benefits. What to build into the trust now, and the single move that will allow you to make meaningful changes later without starting over. Get it wrong and you either disqualify your beneficiary from benefits that they may really need later, or you lock them into an overly restrictive estate plan that may not be in their best interest. Both happen, and both are preventable. The first thing to know is that having a disability and getting disability benefits are not the same thing. Disability benefits like SSI have a work threshold that is really the core focus when we're testing whether a beneficiary will receive these types of benefits or not. Having a documented disability and qualifying for government disability benefits are not the same thing. Even with a diagnosis and credible medical evidence, the focus for many disability benefits like SSI is whether that child can work in the United States job market, doing something. Doesn't need to be something that they choose, just something that's available. And so even with a diagnosis and credible medical evidence of an impairment, we're really asking instead, do those things together prevent this child from working meaningfully in the United States job market? So an autism diagnosis or a Down syndrome diagnosis or many other types of disabilities alone are not enough. When we're creating an estate plan for a child who has a disability, we're often confronted with the opportunity to create what's called a third-party special needs trust. And this is a proactive planning tool that parents or grandparents or really any third party can create to leave an inheritance to a specific beneficiary, and that money or those assets not count against them for these public disability benefits. This is as opposed to a first-party special needs trust, which is referring to the source of funds entering the trust itself. When we're creating a third-party special needs trust, third party relates to the source of funds being someone other than the beneficiary themselves. When it comes to a first-party special needs trust, the source of funds are the beneficiary's own assets. It could be inherited property that was not planned for. It could be a substantial settlement from a personal injury or birth injury. It could be money that they've accumulated or earned over time prior to being deemed disabled. Any of those types of assets would be considered first-party assets when we're creating this type of trust. If your child is over 18 and you haven't reviewed your plan since their diagnosis, the link below is the next step. When we're creating an estate plan for a young beneficiary, it could be a minor or a young adult beneficiary where there's a lot still unknown, it's important to create a trust structure that is revocable, which means that we can change it over time. We can make modifications instead of creating a new trust from scratch. We can change trustees, remainder beneficiaries, the structure or rules of the trust as circumstances or regulations change over time. It's also important to understand how benefits can change over time. If a child receives SSI because they were deemed disabled when they turned 18 and their disability onset was prior to age 22, their benefit eligibility may change when you retire and draw Social Security, become disabled in your own right, or when you pass away. Your child's SSI benefit turns into what's called DAC benefits, or disabled adult child benefits, changing their entitlement from SSI to a portion of your benefits. This will increase the child's monthly stipend to be about half to 3/4 of what your benefits would be under Social Security. This will also shift their entitlements from being Medicaid only to also add Medicare about 2 years after this triggering event. And of course, when we're planning for a child with a disability, we have to plan for their entire lives, not just yours. And so the focus on who will take over after you're gone can sometimes result in a short bench of candidates, either because you don't have a great number of people in your family or in your close circles who would be willing and capable of serving in different roles like trustee, Or it could be that your child is the youngest of all the people we're talking about, and there's a chance and maybe a high probability that they would survive everyone. Utilizing a corporate trustee can be crucial in special needs planning because it's going to be professional trustees who have a heightened competency for these types of trusts, but they also have longevity. Trust companies, law firms, banks generally can't die. And so if someone in your life that you would otherwise name is probably in the same generation as you, we're not thinking that far down the road. Corporate trustees can be a solid first option if we're worried about somebody not doing the right thing or maybe making a misstep along the way, or if we're just short on opportunity for a long-term trust administration. They can be a great backstop trustee. Parents in North Carolina with adult children with disabilities are probably one of the most underserved groups of clients that we work with. Most plans that I review were drafted well before the child became an adult and haven't been touched since. If that sounds like you, the link below gets you on my calendar. Protecting your family requires more than just standard documents. Schedule your consultation with our team today.